I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the client on what he says in the affidavits is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does not, or rather does, undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted, and that he's still giving evidence with the effect that the threats are going to materialize again, with all respect, because effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, I read this to mean that the commission has killed, underline the commission, has killed 2 people, and that Mr. Carrim will be the 3rd person it kills if the commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Carrim have that the commission has killed 2 people?
Chair, may I say that I hear what the commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the commissions, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the commission killed anybody, but that the commission has experienced, in Mr. Carrim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the Commission if that indeed caused the offence as both being gratuitous and sensationalist.
Thank you for the withdrawal and also the apology. Right at the end, in my notes on engaging with you, I was actually going to call for an apology for this. But let me conclude the debate on this aspect, subject to whatever response you may have, by saying that, yes, earlier, as you indicate, there is reference to incidents. But Commission's kill rate, that cannot mean anything other than that is the rate at which the Commission is killing. The Commission's kill rate. You cannot, I just do not see how one can seek to change that. And that kill rate, or the rate at which the Commission is killing, is going to result in a hat trick. That is Mr. Carrim being the third person the Commission kills. That is my reading of this, and I found it quite offensive, but you've apologized. It is the Commission's kill rate. It's nobody else's kill rate. It is the Commission's kill rate.
Chair, without repeating indulgence,
I don't want us to debate the point I made, because I think the preliminary point has become, I think you should just leave that prayer. Prayer 2 must just be abandoned. And when you deal with prayer 3 and 4, I will tell you what my concern is.
Before the merits, may I? Did I get the impression that, but for our engagement, you were done with your submissions, Mr. Premier?
On the preliminary, yes, I think it's only fair that Ms. Hassan
Yeah,
gets an opportunity
that's where I want to go
respond.
to. That's where I want to go to.
Although
Are you accepting you abandoning 2, so that we don't need to debate it?
I would prefer the Commission make a ruling against me rather than abandoning it.
Okay.
All right.
Thank you, Chair.
Ms. Hassan?
Thank you, Chair. I mean, in the light of the questions that came from the Commission, I can be brief just on the preliminary point. I think we should probably just get straight to the merits, because as Commissioner Baloy says, this issue of the preliminary point has become academic. After the first, I think it was only after the first minute or two of my learned friend's address, we strayed right into the merits. And so part of what's been debated, in fact, concerns the merits of the application. But even though, that should be the end of it, I would like to say 1 or 2 other things. The first is that my learned friend says that he did not understand the session today to be a session in which it would be a public one. And I must say that's hard to understand in the light of the directive of this court on the 3rd of March.
Commission?
Pardon me, of the Commission. I must wear my other hat. In the light of the directive of this Commission on the 3rd of March, which stipulated that it would be heard in open session. Now, even if that were not a live broadcast, what it could not be understood as is to be a session that would be closed to the public. So even if it were not a television broadcast or live streaming on other platforms, this was going to be an open session, open to the public and open to the media. So any reporting or any coverage, photographs, anything would still be permitted in an open session. So it doesn't aid my learned friend to say that, understanding of what an open session was that it would be somehow closed and that it would only be perhaps the legal representatives and the commissioners. On the statement, let me say, the statement, it's always been the practice of the Commission, and there's never been a breach of confidentiality thus far, not in relation to this witness or in relation to any other witness on the side of the Commission staff or evidence leaders. So that is not something that ought to have given rise to some suspicion.
But on that, I can imagine that Mr. Premhid will probably say neither he, his instructing attorney, nor Mr. Carrim knew that procedure.
That was, and let me say that there has been some clarification in that regard, that statements that are given, the practice is witnesses provide statements to the commission before they appear before the commission to provide their oral evidence. It's only once the witness testifies that the statement becomes public. So it would only be on the determination of this application, which would then determine what kind of procedure follows next, that the statement would become public. That's the second thing. The third thing I want to say is that in relation to the perceived threats of the breach of the ruling of this commission, it is important that witnesses understand, and the legal representatives, what the requirements are of the commission and the status of rulings that are given by the commission. So it wasn't in the nature of a threat. It was in order to advise the witness that you now are in breach of the ruling of the commission, and it's important, and a duty, I would add, of the evidence leaders to protect the processes and the integrity of the processes of the commission. So a ruling that says that the statement is to be provided on a certain date is that. It cannot be amended without the chair's reconsideration of the ruling, which would require an application, and there was none such application in that regard. And finally, on the statement, it really wasn't tied to the determination. It wasn't conditional on the outcome of the in-camera application, right? Because the statement is for the purposes of providing evidence to the commission. So I just wanted to make those remarks with regard to the statement to clarify that. But I've also said what I've had to say about the ruling on the 3rd of March, that this was to be an open session. For me, that's where this preliminary debate would end. And then given that the ship has sailed, we should probably proceed into the merits of the application. Thank you, Chair.
Thank you, Ms. Hassim. Mr. Premhid, one last. Yes.